Under the Sixth Amendment's Confrontation Clause, a criminal defendant has a right to cross-examine anyone who testifies against him. Does this right still apply to testimony that's only indirectly against the defendant? The United States Supreme Court explored this question in Samia v. United States. Katharine Lee was found dead. The federal government's theory was that Adam Samia, Carl Stillwell, and Joseph Hunter had been hired to murder Lee, and that Samia and Stilwell had lured Lee into a van where they shot her. Stillwell confessed to law enforcement that he'd been driving the van, but Stillwell claimed that Samia had pulled the trigger. All three defendants were tried for murder and other charges in a joint trial. Stillwell invoked his right not to testify. The government presented Stillwell's confession through a federal agent's testimony as evidence against Stillwell. To try to prevent the confession from being an accusation against Samia, the agent replaced Samia's name with a generic reference to another person. Specifically, the agent testified that Stillwell had confessed that he was driving the van when, quote, the other person he was with pulled the trigger, unquote. Other evidence allowed the jury to infer that this other person was likely Samia. Twice, the district court instructed the jury that Stillwell's confession could be used as evidence against only Stillwell and not against Samia or Hunter. The jury convicted all three men. On appeal, Samia argued that it was obvious that Stillwell had accused Samia of being the shooter. Because Samia hadn't been able to cross-examine Stillwell about this accusation, Samia's confrontation rights had been violated. The Second Circuit affirmed the conviction. The United States Supreme Court granted cert.